All right. We are back. My name is John Crump, and this is John Crump News. Today, we're going to be talking about breaking news out of California. It broke last night, but I figured it was a little bit too late when I got home from jujitsu to do a story on it. So we are doing a story on it this morning. I am joined by my friend Flying Rich, and we're going to be talking about the TRO denial and the DOJ's case against California against the California Glock ban. So let's go ahead and jump into it. All right, guys. Here is the breakdown, the too long didn't read portion of it for you guys, and then we can get into a little bit more of the nuance. The too long didn't read is the TRO was denied in California against California's Glock ban in a case brought by the DOJ. A judge that denied it is a Biden appointee, but he did not deny it on any type of merits or any type of Second Amendment grounds or anything like that. He denied it on procedural grounds. Let's go ahead and get into this. All right. So, just to recap, California has recently passed a law banning Glock pistols because they are machine gun convertible. You don't know, there's something called a Glock switch or switch that you can attach to a Glock, and it converts the Glock from a semi-automatic firearm into a machine gun. Now, the interesting thing about that is you can convert almost any gun into a machine gun. It's actually easier to convert a semi-automatic to an automatic than an automatic to a semi-automatic, but we're not going to get into that. This brought the DOJ to sue California, claiming that their law banning Glocks violates the Second Amendment and also a bunch of legal precedents that's been set. For example, Heller says you cannot ban firearms in common use, and Glock makes Glock is a handgun, and handguns are in common use. No denial of that, and Glock is the most popular handgun in the world. So when this case came out, when this law came out, and there was another law in Maryland that FPC sued over that's basically identical. The federal government sued, but because of certain procedural things, the federal government could not sue until the law went into effect. So once the law went into effect, the 2A division of the Civil Rights Division of the Department of Justice sued California, and they asked a judge or a TRO. Unfortunately, Benitez is retired, so they got a Biden appointee, and the Biden appointee decided that it is proper to deny the injunction. Yeah, a cruciform trigger, exactly. Deny an injunction, but not on Second Amendment grounds or likely to cede on the merits, but something called 34 U.S. Code Section 12601, which is a procedural rule that the judge used to deny the TRO. So he's like, I don't have to look at this. I'm looking at whether you can bring a lawsuit or not. So I'm saying that under Section 12601, you do not have the right to ask for a TRO. The case is going forward, but the judge is basically saying that because of procedural law and procedural standards, you cannot sue. I mean, you cannot ask for a TRO.
So, and I want to make sure I understand that. Because the law is not in effect yet, they can't ask for a TRO.
The law's in effect now. But they
Okay.
just can't ask for a TRO.
And what's the reason?
Because okay, now I disagree with them, but the 12601 is how like a federal agency such as the DOJ can ask for things like TRO or sue, and it all has to do with standing.
Okay.
And they're saying that, without getting too much into the weeds, what they're saying is the DOJ does not have standing to ask for a TRO.
Just like this case in Virginia where they said the GOA and VCDL didn't have standing, but some rando dude had standing.
Well, that's the different Virginia law, and there's a lot of different arguments on that. So that's a little less cut and dry than this.
Mm-hmm.
This, I believe that the DOJ absolutely has standing. But the judge does not. The judge is also
I guess you said Biden appointee.
Yes.
So if the Fed sued in the past and had standing, I'd love to see the statistics on that.
Well, here's the thing. By the judge saying that, this is a 12601 thing that you don't have standing just to ask for a TRO, he avoids the question of whether the law runs afoul of Heller, which I'm sure it does, or Bruin, which I'm sure it does, or the Second Amendment, which I'm sure it does, because Bruin and Heller doesn't change the Second Amendment. It just clarifies what the Second Amendment
or Wolford
says. And Wolford too, yeah, exactly. So the judge, I believe, knows that there's no chance of this law being upheld. The law is going to get shut down, but it's a stall technique, right?
Yes.
It's a stall technique.
The process is the punishment.
Yeah. So this buys California some time. And eventually what they're going to do. Vulcan Rumble, no, there was no ticks and bangs this week. It was canceled at the last moment. I was doing behind the scenes things. I was preventing something bad from happening, which I was able to do.
You may never know what happened.
You guys will never know, but it was I would say it, for everyone in the 2A world, it was probably worth it for me to throw on a suit and go take care of some stuff.
John was practicing Brazilian jiu-jitsu on some bad guys.
No, I wasn't doing that. I was dealing
with... Can we pre-order the autobiography so we can find out what you're talking about?
It would never be talked about.
Yeah, I know what was going on.
Hurt ribs.
And if you super chat me, I'll tell you.
No, you won't. So basically, the whole thing with where these Glock bans are, and this is the bad thing, right? The California one is in the Ninth Circuit. The Ninth Circuit is in no friendly territory to the Second Amendment. The other Glock ban is in Maryland, which is under the Fourth Circuit, which is actually more anti-gun than the Ninth Circuit. It's not a fun place to be for either of these cases. That's the issue with the whole circuit system, is because courts that are more constitutionalist, more constructionist, as you can say, like the Fifth, the states there don't have the tendency to violate people's rights. The states that have the tendencies to violate people's rights, Virginia, unfortunately, although we were winning in the state courts, but like Maryland, New York, and all that, in California, the circuit courts that they're in are very anti-constructionist. They believe that the Constitution is a living, breathing document that can change by the whims of the courts. So these laws don't really get changed. That's why I'm glad that Veramontes got taken up by the Supreme Court, because the places that have assault weapons bans are in circuit courts with very left-leaning, anti-gun circuit courts. So there wasn't going to be a circuit split. And I'm just afraid that that might happen here. Although they're going to have to do some judicial jujitsu to knock down the Glock laws. Because Heller said that handguns cannot be banned, and a Glock is a handgun. Now, if you
unless
ask
it's a machine gun or an SBR.
Yeah. Now, if you ask California, they're saying we're not banning Glocks. We're banning things with cruciform triggers, but we're not banning Glocks themselves. There's no ban on Glocks. If you have a Glock, you can still keep a Glock. That's one of the things that they do, which is really weird, is they say it's not a ban because people have them, they can keep them, they just can't get new ones. So therefore, it's not a ban, which is absolutely bonkers that you can even try to argue that at all. In my case, for example, they try to argue that there's no ban because people still have the so-called assault firearms, even though you can't acquire new ones. Or they try to say stuff like, well, cops can still get them, therefore it's not a ban because certain people can get them, which is a special protected class, which I think violates the equal protection clause, but that's just me.
Yes, I fully agree on that. You know, there can't be laws for some people and not others. That's not right. That's antithetical to what our founders believed in.
Yeah, we the people are tired. Yes, there is, and the People's Republic of Maryland, they do have a Glock ban. That one's being challenged by Second Amendment Foundation and Firearms Policy Coalition. So there you go. But this was a judge looking at a way to get out of ruling for the TRO, so he used a procedural method to avoid granting the TRO.
I mean, are these guys just chat GPTing like, hey, how can I get out of doing my homework today?
Maybe. But that's it. That's it for today. Just a quick side note. I will be on vacation starting tomorrow, so you might not see me that much. I won't say
your whole life is a vacation.
Yeah, whatever. I won't say you won't see me at all because I've never had a vacation where I made it the whole week without something having to go break news or something. But I'm gonna try.
Never sleeps.
I'm gonna try to avoid that as much as possible. So if I don't see you, you guys have a good week. Have a good weekend. And with that, we are getting out of here. Thank you so much for watching. My name is John Crump, and this is Sly and Rich, and this is the John Crump News Channel. And with that, we're out of here. Bye-bye.